Ladies and gentlemen, from wherever you're joining us from, I was just teasing my co-host and Mr. Nandlall because Anita made some lovely red bread today, very juicy, very nice, and so I was showing them a piece of paper, asking the two of them if they wanted any. But we are on our show, and let me welcome each and every one of you to this room 592, where we unleash the truth. We are privileged to be joined by a gentleman who we have invited here for more of his technical competence rather than his political affiliation, and that is former Attorney General Mr. Anil Nandlall. Ladies and gentlemen, I just want to say this in the beginning. We all know how these elections have gone. We know it's 140 days now since election day. Today, I've never seen such thrashing. I've never seen such licks. I've never seen such. I can say this. I know counsel wouldn't say this. But ladies and gentlemen, the words that the Chief Justice has used today, if one could have any degree of shame, you would feel embarrassed that we have taken this country down this road where a court will say, why are you bringing these matters to us? It's res judicata. Why are you bringing these matters to us? And Mr. CEO, you are a creature of the commission. You are not a constitutional authority. So, ladies and gentlemen, I want to defer for his words, for his take on what happened today to Mr. Anil Nandlall. But however, sir, Mr. Nandlall, I want to beg you a favor. You are a legal mind of which I hope when I get big, I'll become like you, sir.
You're older than the man.
But I must tell you this, sir. Um, is there anything Yog Mahadev can do to stop Mr. Basil Williams from speaking that, Your Honor, all of Guyana await this and all of Guyana wants this because Mr. Nandlall, not all of Guyana, maybe he wants to, but he cannot be representing all of us. But over to you, sir. Please tell us in your minds and in your words what we need to hear for today's show and today's case. You're muted.
Are you hearing me?
Yes, very clearly.
Yes. Permit me to say good evening to your viewers and listeners and to thank you both for inviting me to be part of this program. Yog, I have to agree with your opening sentiments that I have not heard for a long time a court being as forthright, as crisp, as clear, and as almost reprimanding as the learned Chief Justice was in every single one of her pronouncements. You could see their judicial frustration, if not disdain, being expressed by the Honorable Chief Justice to say to those who continue their relentless attempts to rig the elections and to steal the next government that you will not succeed. Do not come to the courts, do not come to the judiciary to give imprimatur to your illegal design and your fraudulent pursuits. And that was, I believe, the tenor of that judgment. That was the scheme, the underpinning of that judgment. Because the learned Chief Justice, every single argument that they put up, it was dismantled in a very clinical and almost cruel manner. The Chief Justice, first of all, I believe, took jurisdiction so as to annihilate them. Because had the learned court did not take jurisdiction, then you would have had them running around like headless chicken again to say that, these matters were not pronounced upon by the court. The court said it didn't have jurisdiction, and therefore they will have to take it to another court to relitigate. So the Chief Justice took jurisdiction and basically held them up in her hands and use a wild cane, bend them over, and bench them relentlessly from one end of the judgment to another. I don't know what them and their trolls are going to say now. I see Harman, a lawyer of over 2 decades standing, issue a brief release a few moments ago in which this guy shamelessly says that the court did not deal with validity of votes. This is what this gentleman says. And I can't use gentle to describe this guy anymore. It is disappointing that in its ruling today, in the case of Messenger Jones, the court has sidestepped the issue of fraudulent ballots in the tabulated votes and the recount. It looks as though you have to take a 10-inch nail and drive it into these people's head with a hammer. Because I don't know what else. English language is not penetrating the thick skull that is on the neck of these people. Right. I don't know how else to put it. Because the Chief Justice over and over in her judgment said that the recount order and the electoral regime, legislative regime, do not permit the determination of validity of votes, that validity of votes are ex facie valid, that votes are ex facie valid that were counted. And Her Honor reiterated that that is what the CCJ ruled.
Correct.
These people are either deaf, they are either dumb, they are either blind, or they are a combination of all. Plus, they are there's a word called thanatoid, meaning brain dead. Perhaps they have entered that stage because I don't know what else to say to describe them. So let us go through the judgment, the important facets of the judgment.
But counsel, just before you do, if I may,
yes.
Because just for our viewers and listeners to get this, I found it ominous, if you don't mind me saying so, sir. I found it ominous that Mr. Williams at the last moment there, he used the words that almost in my mind spoke poorly of the Court of Appeal. In other words, this man has said, I know we will win at the Court of Appeal because this matter will end up at the CCJ. Counsel, I know that it is not habitual that we discuss the court and what they will do, but isn't it passing strange that Williams would at that stage almost intimate to this nation that we are going to win at the next level?
Well, it is ominous that you are taking Williams seriously too. Because Williams has demonstrated himself to be a national, if not an international joke.
Right.
Nothing this guy says even makes sense. More so can be taken seriously. Nothing. Did you hear him say with a dry face that it is expected that GECOM will not do anything and that the nation is expecting a resolution of this matter, and therefore the judge should grant some kind of order that would preserve the status quo? Yes, that Williams is saying that the nation is behind this case. This case is a public nuisance to the nation. It is an irritant to this nation. It is causing this nation anguish. The nation knows that there is no case. This is not a case. This is just another relentless attempt to rig the election and steal the next government.
Correct.
And they're going, because Mingo got caught and Lowenfield got caught, and they are unable to get Mingo's declaration to be used, and they are unable to get Lowenfield's fraud to be used, fraudulent report to be used. Right. Imagine they believe that they can go to the court of law so that a court of law will permit them to use fraudulent results to declare the elections. You have to be mad. You have to be insane to think that any court worth its salt will take you seriously. No judge will want to ruin, no judge will want to ruin their career. Any judge. And I'm saying so without any, you know.
Right. And Counsel, just one last clarification before we get into the decision itself. For the sake of our viewers and listeners, if the applicant, which is APNO ASC, fails at the Court of Appeal, is that the end of the matter, or anybody still has a chance to go to the CCJ?
Well, the PAC, remember their agenda
Mm-hmm.
is to steal. They are a band of thieves.
Yeah.
Thieves are normally relentless. They have no shame. They have no dignity. They have no pride. And a thief will not stop until he gets the booty or he exhausts all the processes available to get the booty.
Mm-hmm.
So that is what you're seeing here. So when they lose at the Court of Appeal, they will go to the CCJ. Remember, one of their objectives, if they don't get to steal the government completely, is to stay in the government to parasite off the backs of the people as long as possible, to plunder the treasury as long as possible, to drive around the country with their drivers and their sirens, and to pay themselves this hefty salary as long as possible. You understand?
Yes.
So the longer, whatever keeps them there, as long as possible, they are going to stay there. You understand?
Yes.
Remember, these people have no pride. If I have taken, as a lawyer, I'm a professional. Every professional has pride and dignity about what they do, about how they carry themselves, about how they present their arguments, about how their professional peers feel about them, about how, if you're a lawyer, how the tribunal feels about you. You don't want to carry yourself in such a way, conduct yourself in such a manner, take on cases and present arguments that are of the type and quality that would cause you disgrace and cause you shame in the face of your people, more so your professional colleagues and a tribunal before whom you have to appear for the rest of your life, all things being equal. Moreover, in a case that is being broadcast live throughout the world, these things do not affect these guys. So you have to be of a special pedigree. You have to reach at a particular low before you can say what these guys are saying. Mm-hmm. And you can do what they are doing. And look at if you look at them, the way they were speaking and so on.
Correct.
You're dealing with that breed here. So you can't discount that factor.
Correct. And Counsel, just for our viewers and listeners again, I mean, sorry, I know we'll get into the substantive discussion in a minute, but it was also interesting that the Madam Chief Justice quoted from the Court of Appeal decision of the previous two cases. And so now that they are going to go to the Court of Appeal, they're basically going to the Court of Appeal to ask the Court of Appeal, did you mean this in your own decision? So what about res judicata then? What about something that has been heard before then?
They are possibly going to the Court of Appeal to ask the Court of Appeal that to overrule itself. Mm-hmm. Because the Chief Justice largely based her ruling on the Court of Appeal's pronouncements in Eslin David, as well as in Yulita Moore, and on the Chief Justice's on the CCJ ruling in Eslin David, and to some extent even Ram and Attorney General, which is the confidence motion cases.
Right.
So their excursion to the Court of Appeal, in essence, would be to ask the Court of Appeal to overrule itself or to pervert itself by overruling the CCJ, which is not under the hierarchical structure of the judiciary, is not possible through the doctrine of stare decisis. A higher court ruling binds every court below it. So if, remember, the Court of Appeal felt in the Eslin David matter that GECOM, or more specifically, Lowenfield, can determine validity of votes, or at least Lowenfield felt that the Court of Appeal authorized him to do that. And as a result, Lowenfield invalidated 115,000 votes.
Right.
That matter, when that matter went to the CCJ on that very issue, the CCJ said, "Are you crazy?
Right.
Only the High Court under Article 163 is empowered to determine validity or invalidity of votes." Look, the principle is very simple. When you're doing a recount the night of the election, or a count,
Right.
my brother, you don't count these invalid votes are put one side.
That's right.
What you count is only valid votes, as the Chief Justice rightly said, votes that are ex facie, on its face, valid. And that is what the CCJ said. So it's what Harman is essentially saying, that he will invite the Court of Appeal to overturn the CCJ, because the CCJ overturned the Court of Appeal.
That's right.
In Eslin David on that issue. So we are engaged, unfortunately, in this horrible circuitous process where we are going round and round, and at taxpayers' expenses.
That's
and
right.
to the detriment of our country.
That's right. Thank you, Counsel. And you want, sorry, Leonard, you were going to say?
Yes, I want to ask the good counsel, if it is that you lose at the lower court, the High Court, lose at the Court of Appeal, do you still have grounds to take it to the court, to the Caribbean Court of Justice?
Leonard, as I said, a prudent, competent, respectable lawyer will not do that. Part of your functions and responsibilities and duties as a lawyer or of a lawyer include advising your client or clients when he or they does not or do not have a case. It's not, no lawyer of competence will run with every case that a client brings to him or her.
Right.
A lawyer has a judgment call as part of his professional responsibility to tell a man, look, my brother or my client, you don't have a case. You do not have a case. Don't pursue this. The cost of pursue this far outweighs the benefits that you will possibly derive from it, because you will lose and you will only waste money. It's only them shagster lawyers, Shylock kind of lawyers, who are supposed to take money and prostitute the profession. Remember also, a lawyer owes a duty to a court, which some may argue and will argue and have argued is a higher duty to the client. And that duty to the court includes, but is not limited to, not taking matters that are unworthy of litigation.
Right.
Every lawyer has a duty not to abuse and manipulate the process of a court. That is why you are deemed an officer of the court. Being an officer of the court, a lawyer is shouldered with certain deep, sacrosanct, and abiding responsibilities and duties.
Right.
That is why the profession is described as that noble and honorable profession. These adjectival descriptions were not attached lightly to the profession. Why do you think doctors are not called so, or engineers or accountants? Because there is a degree of nobility and honor which go with the legal profession. And that is why you're still, in certain jurisdiction, you're still wigged and you're still robed. In Guyana, you're still robed. to capture a particular aura. All of these things have gone to the dogs because of politics and the desire to steal a government. And all of these principles, doctrines, and precepts are being tossed aside by this band of lawyers. And they are my colleagues. They are my colleagues. It's not that I have anything personal against them, but it affects me when I see the level to which they are descending. I am a lawyer politician too. You ever see me go to the court and abuse the court system in this fashion? I will never do that. Competent, responsible lawyers would not do that. But you see what is going on here. Why you, on what basis, what can you persuade yourself? How can you persuade yourself that the law will ever be that a chief elections officer can prepare a report which does not reflect the will of the people cast in the ballot box and use that as the basis for the declaration of the final results for that election?
Correct.
And
how? That is the crucial issue. And that is what they want a court to give them a judicial approval for. Imagine, Yog, if in 2015, Keith Lowenfield had used not the votes cast, but a different formula, prepared a report in 2015, and declared Vishnu Bandhu of URP the president and URP the new government, and threw away all the votes that APNU AFC had gotten. What would have been the position? Would they have found that acceptable? Would they argue that Lowenfield was right and Lowenfield can be touched and Lowenfield is the Lone Ranger and he's above the commission, and the commission, whatever he says, is the commission is bound by whatever he says, irrespective of the fact that what he says bear no relationship with the election, with the ballots?
Correct.
You see how the level of insanity these people have descended to?
So, Counsel, as we get into the nitty-gritty of the decision today, one more of our layman questions for you, sir, from one of our Carl Prasad. At the Court of Appeal level, sir, will anything new be allowed to be presented, or they have to stick to the same submissions for which the case was dismissed?
An appeal, as the name suggests, is a review of that which transpired in the court below for the purpose of determining whether the parties had a fair hearing and the tribunal below applied the proper legal principles in arriving at the conclusion that the tribunal arrived at. So, in the ordinary course of things, new arguments and new principles and new submissions are not permitted to be made or raised. Of course, if one wants to do that, then one has to get special leave of the court and must show good reason why this submission should not have been or could not have been made in the court below. Now, if it deals with a new fact which arose after the court below made a ruling and is somehow relevant to the appeal, of course, that will be taken into account. But all things being equal, it is simply a review of that which transpired in the court below. And as a result, a court will not ordinarily or ought not to ordinarily permit new matters to be introduced.
Right.
And
so by virtue of your response then, it is the same cut and paste that is going to go. Same cut and paste matter is going to go to the Court of Appeal then.
Unfortunately, and it is inane, it is dead, it has no, I don't have any interest in the matter anymore. I could shut my eyes and I could tell you all the issues. Look, I did an interview which is published in today's Kaichor News yesterday afternoon. And if you read that, If you read that, and I was careful, I was careful in what I was doing not to be accused of attempting to influence the outcome of the case.
Correct.
But all I had to do was to stick to what are public information.
That's
So I went through the recount process. I went through the law. I went through the Ulita Moore case. I went through the Eslin David case in that interview and extracted the relevant principles and concluded the identical way that the Chief Justice concluded without making one single reference to the matter before the court.
right.
And Yogi,
Because the law can't change, the events can't change. There is no principle of law that will authorize GECOM or the CEO to declare a result that is different from the ballots cast by the people. No principle at all will ever allow that to happen. And that is the crux, that is the pith and substance of what is going on here. They want the wrong results to be declared.
And Yogi,
Yes,
if I may, as the good counsel, so I think we're looking at maybe about a dozen court cases so far since March the 2nd. Counsel, how much would something like this cost? And could the people of Guyana go back and sue somebody to see if they could get back this money if it is that the state has paid? Why should the state pay? Have they saddled us? Do you know?
Well, you have, that's a very interesting question, Leonard, because you have the cost that the state has to endure on the one hand by a judiciary being engaged on a full-time basis to hear these frivolities and abuses. You have the Chief Justice of the country and the Court of Appeal. You saw in today's newspaper that there is a building up of a backlog of cases because of a shortage of judges. So you have the sparse human resources being directed into this area to listen to these frivolities and abuses. Then you have a whole court being activated, live streaming, air condition, the cost of the staff and everything. And you're going through the whole gamut, right? The High Court, the Court of Appeal, and the CCJ. You're speaking about millions of taxpayers' dollars. That's one set of expenses.
right.
Then you have those like the Attorney General who is plundering the Treasury. And you have this whole band of lawyers who are appearing for Messenger Jones, a young lady whom I don't know, but from all indication is a person of straw, a person who was, at the recount center, I am told, manning ballot boxes. Yolita Moore was some unknown person from Better Hope South. And the other one, Eslin David, I understand is a lady who sells newspapers in Sophia. But these people are able to retain a large number of lawyers, both locally and from outside of Guyana. So you have 3 or 4 Trinidadian lawyers, 2 of whom at a minimum I know are senior counsel, and those people charge a lot of money. So obviously, and it is no coincidence that all these applicants are somehow connected to APNU. They are connected to APNU somehow. This one here, Messenger Jones, was a polling agent, and then was working for the APNU at the Recount Center. Yolita Moore was a candidate. Eslin David somehow was connected. And the other important thing too is that the Attorney General always supports the case of the applicant. And if APNU is joined as a party, they were not joined here, their lawyer also support the case of the applicant. And the CEO, the corrupt Lowenfield, is obviously a profound member of that team because his lawyers always support submissions of the applicant or the APNU-sponsored person.
Right.
I say that to demonstrate to your listeners the deep ancestral relation between all these persons, and they have a common connection to the treasury. So no doubt monies are being plundered from the treasury to pay these people while the country suffers. But I am hoping that at some point in time, forensic auditors will examine these transactions for the purpose of, going forward in a particular direction. So it's a good question. These litigation are causing the state hundreds of millions of dollars at every stage of the process.
Yeah. And unfortunately, it's happening when we have children to feed and mouths to feed because of COVID-19, talking about getting our priorities in order. But,
But
Council,
but
Now that we
yo,
have,
quickly,
Yog,
I really
now that
wanted to
we
get
have,
from the council whether a private citizen could sue for these frivolous, inverted commas, frivolous
the recovery cost
filings.
to me.
Yes.
yes, at some point in time, a lot of novelty is happening. I can't see why somebody can't sue the attorney. But you see, you got to sue the attorney general. You got to sue all of them, the whole leadership of the PNC, and
Right.
bring them to the court.
Hmm.
But Yog, I wanted to just add to what you were saying. Is that we have mouths to feed? We do, but we are not feeding them.
That's right.
We are using the money instead
Exactly.
to go to court to litigate so that we can continue to stay in government, so that we can continue further to plunder the treasury and live off the backs of the Guyanese people.
Right. So to come down to the essence of today, then, Council, I would want to defer to you to take us through, because I found a couple of things extremely instructive to us from a non-legal perspective. For example, that the Chief Justice chose certain phrases. The CEO is not a lone ranger. She chose certain phrases that I believe were well said, because I think she realized what is happening, but because she's guarded legally, she got to be guarded with what she says. And I certainly believe if the lady could have cussed, she would have probably used some choice phrases. But Council, she also said that in her mind, 177(2)B speaks to anyone who holds the office of the Chief Elections Officer, and that was as hard a slap as anybody could be delivered.
Well, let's go in priority, in order. Right?
Yes, please. Yes, please.
The Chief Justice made it again clear that the recount process is valid, that GECOM had the power to conduct that process. She examined the entire process, as the CCJ did, and pronounced in the end that it is valid and binding, and that the results must be used for the declaration of the final results. That is one important point, right? She went through the order and she said that there is nothing in the order that is invalid or illegal, and therefore you can't follow the order, whatever the order, and the order didn't determine validity of votes, etc., and therefore the order and the recount process are preserved legally, and that the results must be used. So that's one. Two, she says that the RO's declaration for the 10 region, including Mingo's declaration, were overtaken by events and cannot be used. Thirdly, she said that GECOM nor the CEO have the authority to determine invalidity or validity of votes. That the votes that were counted are ex facie valid. That any determination beyond that must be done by an election petition. She says anyone who wishes to examine the legality of the recount process and the recount order beyond what she has done or what she can do will have to do so by an elections petition after the declaration of the results. She said that Lowenfield is compelled and obliged and has a duty only to declare the results produced by the recount process. That Lowenfield cannot arrogate unto himself the power to use any other figure than the results from the elections. That in addition, Lowenfield is subject to the direction of the commission, and he must carry out the direction of the commission.
Right.
That Section 18 of the Election Laws Amendment Act is valid and constitutional.
Right.
That there is nothing in Section 177 of the Constitution that authorizes Lowenfield to depart from the directions of the commission or to use any other results than the results produced by the recount process. That GECOM also is duty bound to direct him to prepare that report using that result process numbers. And that GECOM can't tell him use another recount number anyhow.
Right.
That is the same number that they have to use. Because, as I keep pointing out, the fundamental principle in election laws is that the results that are eventually declared must reflect accurately the will of the people as expressed in the ballot, by the ballot on elections day.
Right.
You can sing from now till tomorrow morning. That principle will not change unless we radically change the system of elections in our country and around the world.
Right.
And so those were the fundamental rulings or pronouncements that came from the Chief Justice.
Yes.
Whether she got them from, whether she found most of them she found to have been decided already and are therefore res judicata, either by the Court of Appeal or the CCJ, and the other set of them, she found that she was bound by the doctrine of stare decisis, by pronouncements made by the higher court. However she arrived at those destinations, she pronounced conclusively and definitively on those issues. And those are the issues that seem to be causing some kind of contention or fabricated contentions. So the Chief Justice has pronounced with great clarity, emphasis, and precision on all those issues. So when Lowenfield is given this direction this time, I don't know what he will say. What will he say? Well, he doesn't understand. Or if he's dismissed, as I have advocated that she should be done, that should happen.
Right. Right.
Or, and I'm advocating a third thing now, as I did in the newspapers, Stabrook. Now we have reached a stage in the process where you have had 3 judicial pronouncements on the same issue. If you have a recalcitrant CEO who has gone rogue and is producing results that are against judicial pronouncements, and the court has articulated that he is to produce the right results, what is preventing GECOM, in the interest of justice, in the interest of impartiality, in the interest of fairness, which are duties that they have under Article 162 of the Constitution, what would be preventing GECOM from taking those results and declaring them? Which court subsequently will fault a commission for taking such a step? Will you take into account a minor infraction of procedure to defeat the substance which is right. And what is the substance? What is the objective of an election? To reflect the will of the people. And if you have a rogue officer that is thwarting and frustrating and perverting that process to prevent the declaration of the will of the people, and a commission takes it upon itself and do so, and in so doing usurps the function of the CEO, which court would fault such a commission? The court, all the court will say that yes, there may have been a violation, but that responsibility or that duty is not mandatory, but directory only. So the word shall, where they say that GECOM shall act upon that report, that shall will be interpreted to mean to be directory only and not mandatory. And we have a million examples that I can cite where shall has been used in appropriate cases to arrive at justice. Shall has been used to mean permissive and not mandatory, directory and not obligatory.
Correct. So Leonard, that clears up quite a few of the questions that would have come in even today during the day, because Council, a lot of persons have been concerned because we have heard persons like you articulate a position that the chairman can, if you have a recalcitrant, you have a unwilling officer like the CEO, that whether the chairman can do this on her own, and you have certainly cleared that up.
And I am using your platform, Yog, to call upon the chairman to do so. She does not necessarily have to await another futile round of litigation. Right. No stay has been granted.
Right.
No stay has been granted. But how long are we going to allow ourselves to be frustrated?
But Council, I found it strange that, and again, this is from me and maybe Leonard Gildari, we found it a concern that the Council for GECOM took the position again to say that, yes, we have always been waiting on the court and there is no reason to say we wouldn't. Because I felt that this was the moment to say, well, we have given this as long a time as is possible. And maybe now it's time I'll go back to my client and see whether they will change from this, rather than commit like that in front of everybody.
Yeah, that thing did had me a little, sorry about that, Council, but that did had me a little puzzled too. Baffled, if you want to use the word, as to why you would not want to confer with the Council before coming to a definitive position like that. Over to you, Council.
A lot of people are wrongly disappointed. Very disappointed, and with great justification. Learned Counsel unfortunately took the position that she took without any consultation with her client, and that was obvious. I'm not getting involved in lawyer-client relationship here. I am speaking what you and I would have seen, and everyone else would have seen. You would have also seen my intervention, in which I tried to differentiate the previous proceedings where undertakings were given. In those proceedings, there was pending a litigation. There was in essay a litigation pending.
Correct.
Here, there is nothing pending. The case was dismissed. So there is a gap. There is a vacuum. You can't give an undertaking vacuously. An undertaking is like an interlocutory order. It's an interim order. You have to have a substantive action in esse. You must have a substantive action in being before you get an interim order, because the interim order can't stand by itself. It's like a door. It has to be hinged onto the doorpost. So here there was no doorpost. There was no litigation in pending. So there was nothing upon which that undertaking could have been predicated. And that is what I was trying to point out. But unfortunately,
in her words,
proceeded to say what she said.
Right. In her words, the CJ also said the following. She said the CEO was bound to the decisions in the Moore case. Now, if the CEO was bound, why are we still here? I mean, this thing, as we rightly keep pointing out, will go on and on and on. But I don't see that words could be more open and plainly spoken as it was today.
Yeah, but um, Yog, I agree with you. We are singing from the same hymn book, and that is why I spent so much time and energy in trying to explain my understanding of the mentality of the lawyers that are involved
Right.
and the mentality of those who are instructing them.
Hmm.
Ordinarily speaking, ordinary human beings who have ordinary intellectual makeup will not behave in such a way.
Right.
We should not have even had Yolita Moore.
Correct.
Why did we have Yolita Moore? You know what Yolita Moore was for? Yolita Moore was essentially to stop the recount from taking place.
Yes.
And this is after David Granger, president of Guyana, leader of APNU, entered into an agreement with Bharat Jagdeo under the auspices of Mia Mottley, the Prime Minister of Barbados, to do a recount. And then 2 days after, Yolita Moore, a candidate of Granger, represented by Royce Ford, a candidate of Granger, rushes to the court, supported by Vincent Alexander, Corbyn, and Trotman, his three surrogates at the Election Commission, in their attempt to stop the recount.
Right. Right. And Councillor, I want to take you back to, you did address Harmon's statement today because here is, I mean, I want you to put on your political cap, sir, because we know that the legal cap seems to be, the legalese seems to be beyond some of them. But Harman would have said today that we remain steadfast in making our case for valid votes. I mean, they've gone back to this tune of valid votes because viewers and listeners need to know this current case, the Jones case, is where valid votes didn't matter anymore. They wanted to go back to use the fictitious Mingo numbers with 20,000 fake votes. Am I right in that explanation, sir?
20,000, or they give us a choice. You take Lowenfield's 115,000 in validation, or you take Mingo 23,000. Mingo was 23,000, 17,000 of which were not even put in the ballot box.
Correct.
Mingo's figure had 17,000 extra votes that were not cast.
Correct.
463,000 votes were casted. Mingo got 479,000 votes in his tally. When you add his tally to the rest, he reached 479.
Right.
So is fraud and thievery upon thievery.
But
And
sir,
that is what we are engaged in here.
sir, on a matter
And that
of
is why no amount of sanctions will be sufficient.
Gotcha.
Visa revocation to me is just a rap on the knuckles. The international community, by their decision to appeal, by the very decision to appeal, they are demonstrating again an inclination to not respect the democratic process. So by that decision to appeal, that decision by itself should attract sanctions. More sanctions.
True. Well, tomorrow
I'm using your platform to call for that. And Gildario, you got to make all these things into stories for the Kaichur News.
Let me ask you a question, dear councillors, that my apologies there, Yog. Is the appeal court, people are asking, is the appeal court and by extension the CCJ obligated to hear an appeal?
Well, yes, they are going to consider it their obligation to hear the appeal once it is filed within the time and within the in accordance with the rules. But the appeal court or any court can determine the way that it will treat it once it becomes seized of the matter. It may decide that we don't want to hear anybody and just throw it out. It's quite possible.
Right.
That used to happen, but everybody now, this matter is now masqueraded as a matter of national importance and national interest. It is not. It is a relentless attempt by a group of people at the back of Sapphire who wants to steal the next government and thief this election. I don't know why people are getting caught up as it is a matter of national importance. It
Of
is
course,
not.
of course.
It is
Council,
banditry disguised and camouflaged. It's nothing. It's a shameless, vulgar grab for government.
on
So
a
this
matter,
icing and this fancy package that they're putting on it, I don't buy it. It's
of
not
course,
nothing about that.
of course. On a matter of some technicalities here now. This court has said plainly and clearly that the declarations of the various ROs are now part of history, but part of the garbage. It bears no water anymore. Is that right, sir?
Yes, very much clearly. It
Yes.
said that the judge's words, the RO's declaration were overtaken by the recount and by the decision to do the recount. Overtaken specifically by the certificates of recount that came, which reflect the totals of the regions as tabulated at the end of the recount for each region.
Right.
The court
No.
was very explicit. I'm saying repeatedly, Yog, the court is a court that is experienced. The court is a court that was fully apprised from the beginning of these electoral matters. Because remember, we went there very early with Holodar, and even before that, we went there with confidence motion. So this court, as the constitutional court, I believe, has a duty to keep abreast with constitutional issues in the country. And the court obviously was following all these events. So the court understands, quite apart from what well, I don't want to say the court was guided by extraneous matters, but these are issues that are around every day. And the court was able, with admirable clarity, extract from the whole dossier of issues the core issues of contention and dealt with them one by one.
Right. So,
One
Council,
by one.
the reason I asked you about these declarations of the various ROs, so that this matter, if it goes to the Court of Appeal, sir, as far as many of us are concerned, it's already a dead matter to your earlier point. That is, the Court of Appeal cannot overturn the CJ's decision on these same declarations because it is the Court of Appeal that says the recount is good and it is proper and it must go on. Is that right, sir?
That's correct. And the Court of Appeal in Ulita Moore, one of the issues that was raised in Ulita Moore matter, remember they were saying, they were arguing against the recount taking place. They were saying that GECOM did not have the power to do the recount because you had 10 ROs declaration. And the 10 ROs are the statutory officers with the power to grant recounts, requests for recounts, and they did not grant it. And once they didn't grant it and they have counted the results and they have declared it, GECOM can't usurp their functions, or else GECOM would be violating the Representation of the People's Act.
Correct.
And all of that is CJ rehashed today in her judgment. All of those matters were decided by Ulita Moore in the Court of Appeal.
Indeed.
Understand?
Council, from a political perspective, ACNO AFC as of this moment has taken or has adopted the narrative that this is some constitutional matter. Other than them challenging the constitutionality of Section 22, what else here is a challenge to that has not already been forthrightly dealt with the CCJ, that is a constitutional matter?
No, they are saying that it is a constitutional matter, that is a matter that concerns our democracy. It's a matter that is of national importance. As I keep saying, it is none of that. It is their disguised attempt to steal the next government. And I'm not going to change that phraseology. The litigation is a device. It lacks genuineness. It lacks bona fides. It is part of the fraudulent design to steal elections.
Mm-hmm.
And that is how I will put it. And if I have to, that is why I'm deliberately not arguing these cases. One of the
Right.
reasons is
Correct.
because I may find myself in contempt of court, because a
Correct.
judge may not permit me to say that.
Correct.
You
So
asked me the
that's why I'm
question.
using this public forum to say it, because
Yeah.
I have no respect for this for the litigation. I have too much love and passion for the law and justice and the justice system to see it being abused and kicked about and manipulated in this manner.
Right. Leonard, you were saying.
You want to ask me the question, what else could be done? Well, if somebody could challenge the legality of GECOM. How about that?
Well, then it would mean the elections has to be that there was no election then if you challenge the
I
constitutionality of
don't know,
GECOM
but
itself.
strange things have happened, huh?
Yog, they can go to court and say that unless it snows in Guyana, the election results shall not be declared. And they will go all the way to the CCJ, and it will not snow in Guyana, so the election results will not be declared.
In their minds. Yeah. Counsel, just as an aside, away from this court case, I want to ask your comment. I noticed that today, I think the Public Service Union would have made or come out with a statement on saying that on these elections, and all of a sudden they have become awake and are talking about the recount and valid votes and all of that. Have you managed to peruse their statement and any comments there?
No, I haven't. And if they have said anything that is supportive of APNU AFC's narrative, and I have to say congratulations to APNU AFC. They have finally gotten somebody to support them. Poor Patrick. Is Patrick Yard?
Yes.
Oh boy. He's there for life. There's one organization that doesn't know any democracy. Any person who can be president for anything so long, something is dead and decaying in there. So Patrick Yard has no political weight, and I don't think he has, any credibility. Look, I have reached the stage. The people of Guyana, at least a majority of them, have reached the stage. The international community have reached the stage. The region have reached the stage. The judiciary that have reached the stage. That anybody who are supportive of APNU AFC are either demented or they are as dishonest as they are. It's as simple as that. So you
Right.
want to lose your credibility, you go and support him.
Your
Well, certainly. Yes, Leonard.
I want to ask a question here. I don't know whether I should seek counsel before I ask it, but as we in it and everybody is going to court, I think I would be prepared. I'd ask Glenn to stand behind me. Counsel, would a judge be making an error? Would a judge be making an error if he's sitting making a decision and he has a relationship with a particular minister? Would it be a
Well,
conflict of interest?
look, these things are not unusual. Um, Relationships of a familial type and relationship of a pecuniary relation on a pecuniary basis are grounds upon which a judge ought to disqualify him or herself once one of the parties are so connected to him. In the cases, no one has made the objection, fortunately or unfortunately, though we all know that there is such a connection between a judge and a minister. But for some reason, no one has seen it fit. But judges are supposed to be a special breed of people. Judges are not normal, they are empowered with a great panoply of powers. And judges are, without persons making applications of the type you are contemplating, ought to carry themselves with a certain aura of veneration and reverence. And a judge with such an aura ought on his own motion,
Right.
knowing of such a connection, disqualify him or herself from hearing a matter. Don't wait for someone to embarrass you. Look, there was a Lord Chancellor of England,
Right.
and his wife was a member of Amnesty International. Amnesty International was one of the organizations that were campaigning heavily for Chile's former president, Pinochet, to be extradited to stand trial for genocide or a series of murders. And the Lord Chancellor, he's not a member of the organization, but the Lord Chancellor sat as a member of the House of Lords in a case dealing with Pinochet's extradition in London. And that judgment was vacated. Although the Lord Chancellor had nothing to do with Amnesty International, it was his wife who was a member. But it was felt that there was a sufficiently close connection to have attributed to him a degree of bias. Remember, it's not actual bias that the law looks at. It is the appearance of bias. And sometimes the appearance becomes even more important than the actuality itself. You, for example, if you were a judge and your brother comes before you in a case, you may feel to yourself, and you can persuade yourself that, you know what, I am going to be fair. I am a professional. I am not going to do that because he's my brother. If the other man got a good case, I am a judge. I am sufficiently trained, and I have such independence that I can rule against my brother. But it's not what you think.
Of course.
Is what the ordinary man in the street believes.
Of course.
If a man looking on at that transaction says, you know what, this guy, how this gonna be fair? That man, the judges, and the man is brothers. So it's the appearance of bias that is more important.
Gotcha.
So that's how I will answer your question.
Gotcha. And indeed, I think even in the medical profession, right? You don't treat your own family. You take some precaution and get out of the way so that the fairness can happen. Also, here is another question with regards to the statement by Ms. Kite today. Is the chairman's hands, the chairman of GECOM, is the chairman's hands now tied by virtue of the fact of what was said in court today, sir?
Well, I don't, look, I will give you my technical legal advice. Of course, it is always permitted and permissible for lawyers to give undertakings on behalf of their clients. And once such an undertaking is given, it is normally binding. It constitutes an order of court, so to speak. But that presupposes that there is the foundation and the infrastructure for the undertaking to be made and given exist. In other words, you have to be in a pending case. You can't give an undertaking in relation to a condition that has not happened. What kind of undertaking is that? An undertaking that depends upon what? The occurrence of a future event, and to whom are you giving it? Certainly it can't be to the Chief Justice, because after this case, the Chief Justice is functus officio. So which court will you go to enforce such an undertaking? To which court was it given? The Chief Justice can record this undertaking in her orders today. She never granted that.
Right. That is very interesting. That is interesting.
No, once you analyze these things,
Yes,
you see how
yes.
easy they are. So this undertaking, that is why I use the word vacuous. It was vacuously given. It was not given in any court. It was not given in any proceedings that are pending. This thing here was given in the atmosphere. It's floating.
Right.
So speaking as a lawyer, if I had to argue whether such an undertaking exists, I will argue it doesn't exist. It doesn't exist.
Right. So,
But it
Council,
all depends on how the chairperson of GECOM will interpret it, not me. She's an
right.
independent officer.
Correct. And Council, what, I mean, sorry to ask you this, it seems like a ridiculous question. What next? What's the timeline? Are they constrained to filing by the Court of Appeal by tomorrow evening latest? And does that mean within this week we'll see at least the first administrative call?
Well, the general principle is that an intended appellant or someone who wishes to appeal a decision of the High Court has 6 weeks within which to do that at the Court of Appeal or to the Court of Appeal. Here you have, again, we have to go back to the undertaking, because you had an utterance from Mr. Ford which seemed to suggest that an appeal will be filed tomorrow.
Yes.
So there is, we have to be guided by that. So if the appeal is filed tomorrow, then some time will have to be given for what is called the preparation of the record. Because remember, you're reviewing everything that transpired in the High Court.
Yes.
Now, it should not be difficult in preparing these records. They are fresh. I mean, you didn't have any evidence here, so you have a few affidavits and the written submissions.
Right.
And that will constitute the record. That can be prepared in a day, served on all the parties, and we can have a hearing. Today is Monday. We can have a hearing by Thursday or Wednesday.
Right.
Wednesday may be a little too early, but we can have a hearing Thursday, Friday, and we can have a decision Saturday.
Saturday, right. So by the end of this week, at least this court case should be out of the way, Leonard.
Yes, and it all depends whether the Court of Appeal, which has already been struck down, how many times? Two or three times?
Well,
yeah, building a record there.
Right.
Yes. Yeah, strike two. Straight.
If there's a will, there's a way.
Yes. So, Council, well, thank you so much for that. Leonard, any other question for Council? Because, what matters here now is for us to have our viewers and listeners take note of what next to expect. And certainly, ladies and gentlemen, we can hope that the chairman can see it as being one of the things she can do is to call for a meeting tomorrow. But Mr. Nandlall, I fear that unless Ms. Kite will be so good as to print hard copies and share it out, that the commissioners are going to say they didn't receive a copy of this thing as yet.
Yeah, remember, you have three bright, very, very profound thinkers at that commission: Vincent Alexander, Corbin, and Trotman. None of them are lawyers, but they want time to study the judgment. I haven't read the judgment yet, and I'm speaking upon it because I heard it. I know what it says. And I've been speaking on it for the past hour. But these three profound thinkers who are not lawyers, they want to study it. I don't know what they will learn from it that they don't know. But all of these are part of the delay strategies. But in the end, Yog, I don't know how long they will. They have already managed to stay. If you count from the no confidence motion, you count December, they were supposed to leave they were supposed to have an election by March, right? So since March last year, they have been squatting in government, right? So March to March, that's an entire year.
Correct.
And now from March to July, you're almost what?
Yes.
4 months?
Yes.
So 1 year, 4 months, they have squatted in office. And I am promising the people of Guyana that the PPP, when we get into office, will stay every single day of that extra time that they are staying.
Okay, and that is
Right?
that is interesting because that was one of the questions I have to ask you. Does the PPP's term start? Did the PPP's term start from March 2nd, or is it upon declaration?
The PPP term will start from the swearing in of the president. But
Okay.
there are ways and means for us to get back that extra year. There is still an extra year from March last year that they squatted in office in violation of the Constitution.
Mm-hmm.
So we have
And,
to get that year too.
and Council, I know that we did discuss this before, but more and more with each passing day, you have a set of persons who show that they have no respect for law, order, people, constitution, or anything. And so, going to the future, when the PPP gets into office, are we, is, is Mr. Anil Nandlall still going to look at these people as a fellow politician on the opposite side of the house and continue politics as usual, sir?
Well, it's a difficult question to answer because many people, many persons feel that these people have disgraced themselves, they have disgraced this country, they have abused our institutions, they have abused the Constitution, they have abused the people of this country. But we will have to see, how events unfold.
Mm-hmm.
Um,
Well, they do
at the end of the
represent
day, they have
constituents.
received, they have, they are elected.
Yes, they do represent
They
the
would be
constituents.
elected. They would get a couple of seats.
Uh-huh.
They will form the main opposition party.
Mm-hmm.
And if we behave like them, Yog, that will be the end of this country. The duty of the PPP, or if you want to say the burden of the PPP, historically, from since the time of Chedi Jagan, has always been to fetch the burden of Guyana on our shoulders.
Right,
The
right.
PNC can rig elections, they can throw away ballot boxes, they can break up this country, they can do whatever it is that they want. But it is the PPP. And, I see Mr. Freddie Kisoon speaking very highly of me on your programs. But there's one thing I said that he never agrees with. And I said that whenever the PPP is in government, there is progress in this country. Look at from 1953 to 1964. Examine that period. At night, when this thing is over, we will examine that period. And then we will examine from 1964 to 1992, and we will see what happened in Guyana. And then we will examine from 92 to 2015, and we will see what happened in Guyana. And then we will examine from 2015 to now, and we will see what happened in Guyana. And you will tell me whether you dispute my hypothesis, and not my hypothesis, but my argument based on reality, that whenever the PPP is in government, there is progress in Guyana. It may not be rapid progress, but comparatively, there is always economic and social progress in Guyana. And that is the history of Guyana. I say that, Yoke, to come back to your original position.
Right.
We will have to do all the repairing. You see that we left them with billions of dollars in the treasury. We left them with billions of dollars in the foreign reserve. We left them with good balances in the central bank. We left them with billions of dollars in the extra budgetary fund. What have they done with it? All the extra budgetary funds are exhausted. Our treasury is in the deficit. The governor of the central bank only 2 days ago or yesterday said that we are going to suffer devaluation in the dollar. He's now exchanging at 240 for one. And he's saying that he's going to devalue more, that there is no money in the central bank balances. So look at the productive sector. They're all dead. Rice not producing, sugar is dead. They kill forestry, construction is dead. The country is basically locked down. There is no
Correct.
economics, there is no trade, there is no commerce going on. The economy is as flat as it has ever been in the last 25 years or more. So I don't have to preach. Look at the reality around you. And when we go into government, that is what we will have to build. Again,
Mm-hmm.
build from there. And that
Right.
is what they have done. And
Right.
that is the reality, bro. You
Right.
may those who don't want to accept it, they can put it in their pipe and smoke it. But Anil Nandlall are not making up these things. This is the
Correct.
reality in which we live.
Well, and the bigger issue, ladies and gentlemen, of course, is that an electorate, the entire electorate of Guyana has spoken on March 2nd, and you have a handful of politicians that wants to burn those ballots, to use the words of Hines, burn those ballot boxes. They want to certainly do this and toward the will of the people. And also, I want to quickly come back to this GPSU statement, Mr. Nandlall, because GPSU did make a statement today in which they said that based on them observing the recount, ladies and gentlemen, they're saying based on their observation of the recount that the recount did not produce a credible result. And I just want to highlight this to everybody. Remember, APNU AFC attacked the CARICOM recount to say it was a small percentage overall of their supervision. Well, the GPSU's percentage of supervision was under 3%, 0.3%. So GPSU was there at one station for a couple days, and they decided to make a pronouncement on the entire recount, and that is their statement today. Yes,
But
Councillor.
I am learning something now. I was at that recount exercise every day from morning till night. I don't think that I skipped a single day, and I cannot recall ever seeing Public Service Union there, GPSU. Can't ever recall seeing Patrick Yard there. Can't ever recall seeing any representative of the Public Service Union there. I saw Lincoln Lewis there one day, and he went to meet the chairperson. I remember seeing him, but I cannot remember seeing the GPSU there at all.
Thank you for that, Council, because that type of information is indeed very, very useful as they're playing these plates out for public consumption, ladies and gentlemen. Council, as we start to wrap up our evening discussion, it is sad that not only that the PPP has to be waiting so long to be sworn into office, but of course that the plans that your party would have had is now put back. What is even worse, Council, to come back to court case today, is that all the courts, well, except the Court of Appeal, all of the courts, being the lower court and the CCJ, would have spoken profoundly, explicitly, very openly to these matters. Council, in parting, you are confident that the Court of Appeal cannot but rule in the same vein as the lower court would have ruled.
Yog, no competent court can rule differently from the manner that the Chief Justice has just ruled. If a court decides to rule in any manner different from how the Chief Justice has ruled, then that is either not a competent court. That's all I will say at this point in time. You and I know the issues. Every single Guyanese know the issues. This is no mystery. There's no technicality here. All right, there is absolutely no technicality. These issues are as clear as glass.
Thank you.
So there is no macabre, no trick, nothing. If any court that rules different from this is not a proper court. That's all I have to say.
Great. Leonard?
Yes, I want to ask the good counsel in my last question here. How confident are you, sir, that David Granger will accept any declarations that GECOM will make in favor of Irfan Ali and step aside?
I am not seeing any. Look, David Granger has said that he will bind himself to the declaration of the results issued by GECOM or made by GECOM. In his last public pronouncements, he added some caveat. He said something about declaration being made in accordance with law. Well, the court has pronounced what type of declaration must be made. The type of declaration which must be made, and that is the court of law. That is the court that determines what the law is and what is the legal declaration to be made. And the Chief Justice just said that the declaration which has to be made is the declaration that is produced by the recount. Isn't that what the Chief Justice just ruled? So David Granger's issue has been cleared up. So I will expect him to deliver based upon his public pronouncements.
Correct. And it is David Granger who initiated the recount. Yeah. So he cannot turn his back on it right now. Ladies and gentlemen, and mind you, this does not, and here is my last question to counsel, this does not thwart anyone from their freedom for filing an elections petition after the swearing in. Counsel, with this last case that has gone to the courts where they're saying, okay, forget this recount, please, we beg you, allow us to go back with the Mingo Declaration. Are they virtually killing their own ability to file an election petition?
Well, look, I have been in the cases long enough to have an appreciation of the quality of case they will take to the recount, to the petition. Mm-hmm. The law is very clear on elections, on election petition. Things like missing poll books, things about missing statutory documents, and all these various irregularities that they have pointed out will not have any material impact on an elections petition. That is the law of election petition. The law is more concerned about substance rather than form. Was the election largely free and fair? Did the result declared by the GECOM an expression of the will of the people cast by the ballots? Yeah, one of those questions are yes, the recount will be the petition will be dismissed.
Well, there is a difference though, right? When they go to the elections petition, they will not have the state finance, the state money to back them. So there is that difference. And we don't know how that's going to affect them. But ladies and gentlemen, this has been an interesting discussion from Mr. Anil Nandlall, and I'm certainly going to hand over back to him for his closing comments. I want to remind you all, ladies and gentlemen, that there is one statement. There is one statement that Mr. Joe Harmon made that I, Yog Mahadev, am in total agreement with. And there is another statement that Mr. Mahatma Gandhi said that I want to repeat tonight. And if it comes to it, ladies and gentlemen, it will have to be this way for this country. And I'm saying so on my own personal behalf. The statement Mr. Joe Harmon used was, we will not bend. I want to remind everybody in this country, we cannot bend to a rigging. We cannot bend to a dictatorship. Because if a dictatorship is to be installed, is to put themselves in power, then the words of Mahatma Gandhi will ring very, very true. Because non-cooperation with evil is a sacred duty. Counsel, your closing words, please.
Thank you very much for accommodating me on the program. I think I have said everything that I would like to say.
Yes, sir.
We unfortunately, the people of Guyana, unfortunately have to endure another ordeal of going to court and having the court dismiss the case, and then you go through this hype once again. I will have to come back and talk to you and explain the judgment, and I don't know. We are all getting tired of this. But that is what the PNC is doing to our country. And we will have to endure it because, as you said, Non-cooperation with evil is a sacred duty, and we will not bend. Harman said he will not bend, and we are not going to bend either.
That's right. That's right. Well, thank you so much, Council. And ladies and gentlemen, it's been an interesting night, yet tiring another night, as Council has said it rightly so, in this endless loop at the mercy or at the pleasures of Mr. David Granger and his team. Leonard Gildari will be joining you tomorrow at 1:30 for Elections Watch and COVID Watch. Ladies and gentlemen, it's been good to have you in room 592. Mr. Nandlall, it's been our pleasure to host you again, sir. And we certainly hope that this can come to an end and we don't have to see you back in room 592. But God willing, that will be sooner rather than later, sir. But
thank you very much. And good evening once again to your viewers. Thank you.
Thank you. And let me just say thanks to Kevin Smith and our technical team and Rads, Josh, and everybody down at Kiter Radio, also the Kiter News crew that works hard to bring us the news in the morning. As you know, ladies and gentlemen, I say to you once again, as long as this rig is in process, as long as there's an illegitimate government of Guyana, and as long as there is and will be a dictatorship, we will not bend. We are not going to yield. Non-cooperation with evil is our sacred duty. Ladies and gentlemen, it's been good to have you in room 592. Do have a great night. Stay safe. Bye-bye now.